Once again, good evening, friends. Once again,
Good evening,
LAWVS
sir.
warmly welcome you all to this insight session on arbitration in construction, infrastructure, and commercial contract. A topic of immense relevance in today's complex commercial landscape. LAWVS is committed to provide valuable legal insights to young lawyers so that they can make their successful career in the legal field. We are deeply honored to have Sri Sanjeev Sagar sir, a distinguished senior advocate practicing at the Honorable High Court of Delhi, who also regularly appears before the Supreme Court of India and various tribunals across country. With an illustrious career spanning of more than 27 years, Sanjeev Sagar sir has built a stellar reputation for his expertise in civil, constitutional, revenue, arbitration, corporate, company law, and telecom regulations. He has advised and represented some of India's most prominent entities, including Union Bank of India, DDA, GAIL India, Bharat Petroleum, Asian Paints, Hindustan Unilever, amongst many more. Sir has also served as a standing counsel for esteemed institutions such as SBI, DDA, MCT, GAIL, and Union Bank, and has contributed immensely to the legal fraternities through his pro bono work, association with Legal Aid Committee, and as an arbitrator at Delhi International Arbitration Center (DIAC). His contributions as amicus curiae before the Honorable Court and his career featured in SEC, Manupatra, Live Law stand testimony to his profound influence to the practice of law as a respect guest lecturer at leading universities. Sanjeev Sagar sir continues to inspire young lawyers through his sharp insights and deep understanding of law and justice. LAWVS is privileged to host such a towering personality of legal fraternity to enlighten us and young lawyers. Thank you very much, sir. We warm welcome you in the new session that is on especially on arbitration. A big round of applause to Sanjeev Sagar sir. Over
Thank
to
you
you,
very
sir.
much. I'm so honored and blessed to be here.
Thank you.
Now, I hope that everybody is ready to get some kind of knowledge and nobody will get bored the way I will present myself. The topic is very interesting, construction and infrastructure arbitration. Now, everybody should know that this is a specialized field in which there are only mostly in India two sides. One is the government, the other is a private contractor.
Yes.
And the councils are also mixed. Mostly who represent private contractors initially represent the government. They get all the loopholes, use it for the private parties, and similarly the show must go on. Some become senior counsel, some become judges, and some become master of arbitrations, participating in many events, international arbitrations, and all. First of all, we need to understand what is a construction or an infrastructure arbitration. In the absence of contract, there can't be any arbitration, be it any arbitration. Now, these construction arbitration or infrastructure arbitration depend on the terms of the contract. The terms of the contract before being signed are actually based on letter of intent, which is initially issued by the government agency or PSUs, that is public sector undertakings, or builders like DLF, Parsvanath, or any other builder. And once the letter of intent, which is not defined under any contract act or arbitration act, is accepted, then goes to the second stage of signing of contract agreement. Now, the contract agreement can be very simple. For a smaller contract, like some houses to be constructed in defense colony, or any other place in Delhi or in India, that is also a construction agreement between the builder and the owner of the building. But these are very simple dotted line contracts in which there are mostly two parties. The purchaser or intending purchaser is never a party to that. To such type of contract, in case of breach or default, intending party is always a third party. They usually do not participate in any kind of these arbitrations, nor they are generally permitted also, unless a leave of the court is taken that let me participate in this type of contract. Once an agreement is entered, then comes its performance and satisfaction of obligations. If everything goes right, performance is sound, obligations are good, then there is no problem. The contract goes smoothly and it is culminating into a very smooth end. Now comes bigger contracts. Now these bigger contracts in commercial terms are generally again two-party contracts only. And given the volume of the contract, the contractors are sometimes permitted to take on board subcontractors. These subcontractors have a direct contract with the contractor. The agency who has given the contract will never be party to these kind of contracts. Many a times it is seen that these subcontractors try to approach the employer, which is the agency who has awarded the contract, for release of their payments. Many a times the work is actually affected by the non-release of payments by the employer of the contract. Many a times it is seen that the site is not given on time. Many a times it is seen that the drawings are not given on time. Many a times it is seen that the time of the contract is supposedly 18 months or 21 months or 24 months. When working on the site, people face hindrances, and these hindrances are informed to the employer, which may be government or PSU or the developer, that this contract is facing difficulty for this and this reason, and requests are made to modify the drawings. And in this entire process, there is another party who is called assisting agent, or which are normally like EIL, Engineers India Limited, or PDIL. These are government companies which usually work for the government sector. They are for the assessment, verification, checking, and monitoring of the contract. The agency says, employer says, I cannot monitor the contract. You are one of the finest agencies. I hire you, you monitor the contract. Then, besides a direct contract between the employer and the this contractor, a second contract is entered between three parties. Who is the third party? The third party is right of the third party is originating from the main contract, where the government agency or the builder and everybody says that I will appoint such and such agency who will monitor the contract, and who will be the agency who will appoint independent officials or architects or engineers to monitor and verify each of your bills or your progress in the work. And if there is any defect, there is any problem which needs modification, they will examine that, and once it is brought to my notice with their opinion, I will approve it. So this, after this, whenever there are issues, they examine the issues and sort it out. If there is a defect in the work, the defect in the work is also pointed out. If there is any delay in the problem, delay or problem, or delay in payments being released to the contractor, they also bring to the notice of the employer, and employer with every time is informed that look, if you are not going to release this money, the work progress will go slow, and the time which has been fixed under the contract will not be able to achieve. Now, I give you a simple example. When it comes to government construction and infrastructure work, MCD or DDA gives a contract for building a school or construction of road and or any other aspect. Now, construction of road happens to be a contract which needs support of other departments. Like we need traffic support, we need support of PWD, we need support of NDMC or MCD or other agencies. Now, in this, the contractor is bound to face hurdles. Suppose now contract is awarded, assume contract is awarded 3 days earlier, and the date of the start of the work is today. The contractor writes to the traffic police, please give me space. I have to continue, start with the work. The DCP traffic denies that and says, I will not be able to give you approval for next 10 days. So now the contract is to start today, and for 10 days you cannot. After 10 days, I write to the DCP again. The DCP says, okay, you are permitted from 3rd of November next month. So there is a loss of time for 13 days. Assuming this time was for a period of so this thing called 2 months, the road work is to be done. There is a fixed value contract. Now 13 days are wasted. I go on the site. Again, I face teething trouble. Like on the road, there are trees. The trees cannot be removed. The department who has awarded me the contract has not given me any permission or alternate site to shift these trees. Again, if I go and obtain permission from the environment department of the government of Delhi, again the time will be wasted. So in nutshell, after 15 days, assuming I get the permission. So 13 days I wasted here, 15 days are wasted here. So the time left is only 1 month and 3 days or 4 days. Original period is lost. I write to the department, please give me extension of time. I am starting the work from this day. The department keeps silent and does not respond to any of my communication. So in this process, the contractor is bound to intimate the employer every time whenever he feels difficulty, faces hurdles. So once intimation is given, his job is over. Once an application for extension is given, his job is over. Because every contract contains a clause for extension of time. Even if the clause is not there and a specific denial is there in the contract, that extension will not be granted on any conditions. Because these are all dotted line contracts manufactured by them to compel the contractors to do the work on dotted lines. Now, coming back to these contractors, in construction contracts, there are limited contractors, and for all these contractors, they are registered as vendors with the department. Private person has a right to choose openly from the market. But when it comes to government, the government is always considering the registered vendors. These registered vendors get the contract, and once awarded, they work and they are aware about what is to be done and what is not to be done. I remember Justice Midha once hearing my matter said, Mr. Sagar, what are you talking? You know, these contractors have hired regular counsels, regular men who keep on writing to the department, even if they have to go for a very short break, or if they have to go to toilet, if they have to go for mandir, they will keep on writing letter to department that I am facing this trouble. I cannot hold anymore. I will go. And the department will receive it, and they will sit on that. They will not even respond. If in this manner the country goes, then the government or the government departments or PSUs will always suffer losses of damages and compensation, because nobody is monitoring, nobody is interested in monitoring. So first aspect is the contractual terms. The second most vital aspect is monitoring of the agreement, either by that agency or by the department itself, to the utmost care level. Just not do not leave it once the contract is awarded. Assuming to now, there are situations when the contract is abandoned. Now I come to the arbitration aspect itself. The contract is abandoned. The contract is discontinued because of force majeure conditions, and contract is terminated for the lapses of the government in which it blames the contractor, or the private party determines the contract on a one-side basis on the basis of rights given in the contract. Now, what is the remedy? The remedy is to go for compensation, to go for claim of the work already done, to go for rights which are available under the law, and claim all those rights which can compensate the losses of the contractor. The loss is not only monetary, the loss is again in two types: monetary and reputational loss. Why I am saying reputational loss? The reputational loss sometimes is like this. Supposingly, I face a ban of participating in the tender activity for a period of 2 years. Now that ban will impact me in the entire network industry, which is the government or the PSU or even state governments. So for 2 years, my business will come to standstill. I have to shunt my entire staff out. Many a times people have taken offices. The rent will not be able to be generated. Bank loans are taken. These all get badly impacted. I am giving the backdrop because uh, going to an arbitration, unless you know the basics and the roots and the causes and what is the impact, no arbitration can be successful and nobody can actually arbitrate. Now, arbitration at the end of the day is a adjudication of claims by the parties from a private person who is appointed by the High Court or under the terms of the agreement. But this reputational risk is even deadlier than the claims in the arbitration. Supposedly, I have to claim 100 crore rupees in arbitration, but on the other hand, this reputation goes and I suffer a blacklisting, debarring, or other kind of repercussions from the side of the employer, which is impacting me pan India. I suffer even higher loss. Why I cannot obtain any contract. Now, for that has to be kept in mind that come whatever, I am not supposed to take any step which gets me to litigate with the employer for any breach which is pointed out to me. Try to sort it out as early as possible. If you are able to sort it out, well and good. If it appears that you cannot sort it out, then the remedy is Section 9 of the Arbitration and Conciliation Act before the High Court, lower court, or any other court which is competent to address this issue. The second is, even if once an arbitrator is appointed, until now date, no coercive step of blacklisting or debarring has been taken, then it is Section 17 of the Arbitration Act by which you can take interim relief from the arbitrator. That is equally applicable. If the arbitrator's order is not accepted by them, then under the Arbitration Act, there is a provision you can file a contempt petition against the department or the agency who is in the process of debarring you and obtain a stay, enforcement order from the court. And courts normally entertain these contempt petitions because Section 9 again would not be maintainable in respect of order which is obtained under Section 17. There can't be two interim applications because interim once granted can be only be justified by way of contempt proceedings before the High Court. Now coming to the arbitration. Now normally in every contract, the arbitration clause has always been found to be one-sided. Mostly contracts which were prior in time, at least 3 years before, unless and until this Perkins judgment or Bharat Broadband, these kind of judgments which had clipped the right of the first party, which is the employer, to appoint the arbitrator. Otherwise, in every case, the arbitrator was employer's man.
Sir,
And
may
with
I
that,
ask in a one, sir, both the judgment you have mentioned, sir, what exactly the judgment says, sir, so that all may be benefited for that
what I
particular.
will do is I will send you the title of the judgments after this is, because I just can't give the
Right, right,
SC
right, sir.
title and all. I will give you. Now, what happened in Perkins case was XYZ department had appointed an arbitrator. So the matter went to court and court examined that the arbitrator is appointed by them and what justice it will do to the other side. Now, after the 2019 amendment under Schedule 12 of the Arbitration Act, a declaration by the arbitrator is must that he is impartial and he has no relationship with the employer who has appointed. But most of the times it was found that these declarations are false. And mostly this was happening in the financial industry and construction industry. It was just like a pool of arbitrators, like in construction contracts, engineers, retired executive engineers, retired MDs of all these NBCC, EIL, and similar companies, PWD, DDA, MCD, they were being regularly appointed. And the observation was also no more than 3 arbitration of the same party. Now, they were taking arbitrations, or in finance industry, the same advocate was doing bulk arbitrations. One arbitrator doing more than 100 and passing ex parte awards. The court noticed that. The court said, no more hanky-panky. Appointment only by the High Court. Then there was a shift in the arbitration. 2019 amendment said you can also approach institutional arbitration, like people going to DIAC, Delhi International Arbitration Center. So the clause was incorporated. Sometimes parties, by way of consent, writing a note that an arbitrator appointed by DIAC or PHDCI, this will be acceptable to us. So the change started. Many people came to me also for opinion that is this clause valid? I had to say no, it is not valid. Please do not get into this. So for every appointment where the right is not, a right is always one-sided, where the right is not or one-sided, it is that the parties, it says like parties will, with the consent of each other, will appoint an arbitrator. Normally the parties are appointing arbitrator. They give names of the arbitrator, and normally one side appoints one arbitrator, the second side appoints another, then they appoint an umpire. So many a times that is not accepted because the claim value is very less. Supposedly the claim value is only 65 lakhs. So appointing a three panel of arbitrator is even expensive. So after that, people started going to High Court for appointment of arbitrators, and the arbitrators are being appointed in this manner only. Now coming to this part of why arbitration in construction related matters. In construction related matters, we need experts because expert evidence is must. An arbitrator also has to be an expert. Assuming an Engineers India Limited's report is there in an arbitration that this contract was not performed in the manner, the measurements are wrong, the use of material is wrong, the cement of grade which is used is actually not right. So these are all aspects which have to be kept in mind once person is going for an arbitration. Because an expert can only give an opinion. No, a doctor who is heart surgeon can give an opinion about the cardiac disease of a person, or MD doctor of heart can give an opinion. Can you expect that an animal doctor gives an opinion on a heart cardiac problem? So the appointment process in construction has always been that let us have an expert. If it is a panel of judges, supposedly there are two judges, amongst them, one of them will be an engineer. So if this engineer will be consulted by those two judges that what is your opinion on this? Because judges also understand the basics, but the detailed reasoning can always be given by that engineer only, no? And if required, they will get an expert opinion from outside. Unless there is an expert evidence or an opinion from outside on the subject, there can't be any arbitration. Then there are other aspects also. What are the nature of claims? The nature of claims can be individual, which are simple, requiring no evidence. Supposingly, I say I have filed a claim of 2 crore rupees for loss of my labor. That's a simple claim. Loss of labor, how I will I justify? I have to produce my wage register. Let's see, for 7 months my labor was idle. If it was idle, what is the basic proof? My wage register, everybody marking attendance. Then the second would be my payment proof. These are simple things. And technically an individual claim on the aspect of labor. Or supposedly somebody says, I am only asking for one site supervisor's salary claim because your work had stopped for 7 months. And for 7 months, my site supervisor was there and one security guard was there. Please pay for them. I was keeping watch and ward. Process would be same. I have to establish that he was there and I have paid their salary. Other than this, there is an attendance machine which gives the data, real-time data. It was installed there. Then there are claims which are based on voluminous evidence and documents. So this voluminous documents and evidence will originate from the uh, correspondences exchange between the contractor and the employer. If there is no voluminous evidence or documents exchanged between the parties, a contractor can never establish his claim in the arbitration. And similarly, the department will not be able to justify its claim over the contractor that it is your breach which has led to delay in the work. It is it is your conduct which has caused me losses. Many a times there are multiple parties. When there are multiple parties, there will be definitely multiple claims and counterclaims. And these multiple parties claims are again based on voluminous documents or simple documents and evidences. Again, this is to be examined. When it comes to multiple parties claims, the expert evidence and expert opinion is must. Normally what happens is, I had done the Tech Mahindra arbitration with relation to the government, these websites. And for these websites, we had to call for transcript people from Dubai to record evidences completely and get it recorded audio, who would listen to that, and thereafter they were sending us the audio clip also and the typed versions. It was verified by the arbitrators, it was verified by us, and after verification, we all signed. Well, these are professional, they are licenses. Then there are certain technical, logistical, industry specific legal requirements. Technical, I have already explained. Logistically, again explained material and other aspects. Then industry specific is again the construction related industry specific. In a construction contract, there can't be outside that. We cannot talk on other aspects of arbitration, like we have that electronic and software related arbitrations. What happens in software related arbitration will definitely not be here. And in an arbitration like this, which is actually technical in nature, flexibility and accommodating each other is very important. The parties have to be specific but flexible so that it can be concluded efficiently. and not in a quarreling manner. Normally, what happens is councils do not understand and appreciate this aspect. Those who participate in arbitrations. India, the arbitration is less on a full day basis, and it always starts after 4 o'clock, majority time, because the councils are first part busy in courts, and the second part they come, they drink tea, coffee, eat some chips, pass that 1 to 2 hours, and take a date, which gives productivity is less, and the people are enjoying, making merry and enjoying more. I am at present talking about the arbitration in India only. The arbitration in international market is very different from what is happening here. Normally, these are oil sector arbitrations or government tender related arbitrations, which are happening normally in England, Singapore. Now, Malaysia is also a big hub, and sometimes US also, Dubai also. Many countries are coming up, even the Vietnam has started, so that the arbitration can be done in a smooth manner. And these arbitration normally start 9:30 to 10 o'clock, and minimum the hours of sitting are 6 hours. Like the way the court is 10:30 to 1:30, 2:30 to 4:30. Court is again 5 hours game. They are doing it for 6 hours. And these arbitrator, I have already explained, normally are expertise and in legal or expertise and expertise in the relevant subject. Doing these arbitrations, arbitrators keep in mind industry practice, technical appreciation of evidence is secondary. First, they get into what is the industry practice. Then, in terms of the industry practice, they examine the clauses of the contract. Is the contract in that area is normally based on the industry practice. If there is any deviation, or they have the power to declare a term of the agreement void also. So unless the agreement satisfies that it is in terms of the industry practice and construction laws, that term would be void. Now, construction law is based on the Contract Act and the industry practice. We must have seen illustrations in Contract Act. Then it is the nature of the project, a reputation of the owner, the employer, what kind of litigation they are actually involved in, and what has been their practice. Are they in the nature of traveling their contractors? And also, sometimes they call upon that in how many contracts this contractor has defaulted. Can you get us the number of litigations he is actually facing or he has faced in past? Like in criminal matters, when you go for a bail, the IO comes with a report that this accused is involved in this criminal case, that criminal case, this criminal case. Many times they call for that record also. What was the reason? In arbitrations, relying on settled law is permitted for appreciation. At the end of the day, they have to appreciate the clauses of the contract, no? But giving a fair comment on the conduct of the contractor or conduct of the employer based on their past litigations or continuing litigation is not at all prohibited. And lawyers should actually dig deep and look for that fault or merit of that contractor or employer. Concept should be nobody should suffer. Fairness and good conduct above all. You are taking contract, conclude it properly. If there is a request for this thing called extension and it is a genuine one, please give it. If the time is extended without penalty, please do it. Don't be on a track of giving reliefs with penalty. Nobody wants to delay the work. No employer wants to penalize the contractor. Then there are design architects and engineers whose help and chartered accountants help in respect of claims originating from the payment of balance amount based on the work done. And if the work is questioned on the basis of quality, take a help of and lead evidence of designers and architects. And if it is for the payment of compensation, then please take help of chartered accountants, obtain a certificate, annex your returns, annex your payment details, give to the staff, annex payment details which is made to the heavy machinery supplier, annex payment details of what you have spent as expense, annex expected payment details like your sale tax return, your now they call it GST return, or your income tax returns for at least 2 to 3 years with a certificate of the chartered accountant, so that you can say, supposingly a lawyer goes and say, please pay me 60 lakh rupees, I have lost that. If I ask him that show me your return for last 3 years, and in every year he's earning only 5 lakh rupees, and successive 3 years he will run in only into 15 lakhs, and that 15 lakh man, can he ask 50 lakhs or 40 lakhs? The answer would be no. The proof should not be verbal. The proof has to be substantial evidence. Like in arbitrations, there is no fixed law. It is the substantive law of the country. If it is substantive law of the country, please follow that. Arbitrator has jurisdiction to examine everything which no other authority can examine and decide on these issues quickly. Going ahead, all the parties should know that what are the complexity of the disputes. Again, this would be divided in two parts: complex technical engineering or design. I have already explained. Please get the evidences. Then would be logistical concept. Logistic would be what you have invested in the project, which includes heavy machinery, the material used, and the force you have, all these things. And try to avoid and try to examine the delay aspect first. Now, coming to the aspect of this thing called terms of the contract. these should be reasonable and equitable. If the terms are not reasonable and equitable, the contract terms are void or voidable at your option. Arbitrator can give a declaration to that. Then they should be promoting the business efficacy. This should not be restrictive. If they are restrictive, nobody will be able to work. The employer and contractor have to read the terms of the contract very intelligently before entering it, and same applies to the arbitrator. He has to read the terms of the contract. Like I explained, it is the business efficacy which has to be seen. So business efficacy has to be kept in mind while signing the contract, and the arbitrator has to interpret it and examine that so that it should be free and fair trade practice, not a restrictive trade practice. Then all the terms should have clear expression. If there is no clarity, the term is voidable. And the terms should not contradict to each other. The meaning should not be that if in clause 12 I write this, that in clause 16 the writing changes, then the arbitrator will be confused which is to be accepted, which is to be denied. And once it comes to the notice of the contractor that this thing has come, they should immediately write to the department or the builder that, see, this is an infrastructure contract. In this clause 12 says so, clause 16 cannot be like that. This was actually looked into by Supreme Court in Adani Power versus Gujarat Electricity Regulatory Commission case. It is a 2019 judgment. I will give it in the write-up so that everyone can see that. But I will give it tomorrow. I'm a little. I have to go somewhere. I hope I'm not getting lengthy, and everybody is enjoying. Nobody's sleeping. Just
No,
ask
not
them.
enjoying. We are enjoying, sir. We are very, very enjoying, sir. Please continue.
Because I am doing it very simply.
Very good.
Nobody has said that we are enjoying. Everybody is
Sir,
quiet.
no, sir.
Everybody,
Everybody.
we are enjoying
Anyway,
it, sir.
You are not required to give. You can ask questions in between. I am
yes,
concluding now in 5 minutes.
yes.
You can also ask me questions
Ask
if you feel
question.
like.
Right.
Then the variation aspect is also to be examined. Supposingly, employer in the arbitration says that he has varied the terms of the contract or he has varied the construction aspect. Then contractor should have accurate evidence that, see, your implementing agency was with me. I told them this requires. He writes to me, I'm in agreement with you. Please go ahead. I don't know whether he took your permission or not. I even wrote it to you. You kept silent. If you keep silent, I have done the work in your interest. An arbitrator should agree to that. Then again, there is a factor called disruption. Now, disruption is of many kinds. The arbitrator has to examine all kinds of disruptions. Like in the COVID period, there was disruption. That disruption was complete stoppage of work by the government because of the problem we all faced. In fact, we were disrupted. We were sitting at home. Even though sitting at home, everybody enjoyed. Money is something else, but enjoyment is always supreme. Then nowadays, this Supreme Court imposes construction ban NGT imposes construction ban. Then uh, these environment agencies impose GIRP restriction. How will a contract get completed? So the benefit of all these periods, which are actually force majeure, under the orders of an legal authority, lawful enforcement agency, no contract can work during that period. For that 60 days period, it should get automatic time extension. Then one of the most important aspect is the force majeure. Contractors have been consistently asking for force majeure. Now, this Contract Act 1972 doesn't not define or enlist situations which would gainfully say that these are the conditions in which force majeure will be there. Courts have given certain interpretation, but sometimes there are overlaps, different views of different courts, as it suits, because it depends on the facts. There can't be a general norm. There, in 2023, Delhi High Court in Sarabjit Singh versus Asian Hotels. This is a 23 judgment to appreciate the ground force majeure. Parties would be bound by the clause if they that these would be situations. Normally, government and PSUs put the conditions of force majeure. Assume GAIL has constructed a gas pipeline from Delhi to Ghaziabad, and I have done the work of that. That is also a construction contract, laying of pipeline. Now that pipeline will give sub connections to the vendors of GAIL. The vendors of the GAIL complain that they are not getting gas. The GAIL puts a condition that if I get gas from ONGC or Adani or Ambani, that is Reliance, I won't be able to supply. So for that person not getting connections of supply, the force majeure will be for the vendor, and force majeure will be for him also. The payment that you may have the pipeline, but unless and until it is commissioned, I won't be able to pay you. So force majeure is non-supply of gas by the ONGC, Adani, and Reliance. I hope I am clear on this. Then there are other hardships which a contractor faces. The hardships would be if the site is not provided, so or other kinds of deeds are done by the employer which amount to make performance of the contract impossible. If the contract is not being performed because of the hardship being faced, then the contractor is not responsible. It is the employer who will be responsible. Then there are unforeseeable supervening events beyond the contract of the parties, making performance of contract impossible. Section 56 of the Contract Act deals with that. So these are to be seen when it comes to the construction contract. NGT ban, if not force majeure, it is an unforeseeable circumstance. If it is an unforeseeable circumstance, what is the remedy? The department or the builder has to give an extension of contract, because it is a limited part now, 2 or 3 months or 15 days GRP bans and all. If there is a permanent ban for 2 years, then it is a force majeure event. Then I have already explained, if there are no specifications, no work, no site plan, no work. Then comes, after this appreciation of the contract, would be when to approach court. I have already explained, if you are to seek certain interim relief, go under Section 9 of the Arbitration Act or 17 of the Arbitration Act, take relief. But keep in mind, assuming your problem had originated in the year 2023 and you are in 2025, you are at the fag end of 3 years limitation period. The moment 3 years are over and you kept silent, you get nothing. Forget it. 3 years is the limitation period under Article 3 of the Limitation Act. If the contractor keeps on silent, nothing. Now the Supreme Court has also said you keep on writing a letter to them and they don't respond. That does not mean an admission. You cannot sue them. Supreme Court has again said if they maintain internally that in their balance sheet 3 crore rupees was to be paid and they don't pay and you do not sue them for 3 years, you don't get it because their internal notings will not come to your help. Of course, there can be certain facts which can differ on it, but this becomes a general ruling. Then one has to also see, have you resiled out of terms of the contract yourself, or you have abandoned the contract? You say, I won't be able to do it anymore. Please refloat it on risk and purchase. If you write to them, you will face the consequences of paying the balance amount to the new contractor, or which includes the revised price. Many times you do not perform the contract. You say at the time of construction or award of the tender, the cement rate was 100 rupees per bag, and the other construction material was XYZ. And the period of contract is 2 years. It happens with the steel industry. Steel becomes an important part. Within 1 year of the contract, the prices have escalated. 150 becomes 200, and XYZ become X1, Z1, G1. The government, the institution who has entered into contract with a fixed value one will not give you escalated prices, because in the contract it is already written no escalation. This is a fixed value contract to be completed within a period of 2 years. Once you write on a dotted lines in a construction contract, you will not get escalation at all unless it is codified. You will get escalation after expiry of the 2 years. Or you are able to establish that, see, only 20% work could be done in this 2 years, and within 2 years, the labor cost had increased, the construction material cost had increased. So after this 2 years, I have written to them that I am completing it on the basis of escalated cost. And you are free to terminate the contract here only, pay me for 20% which I have done. Again, pen becomes mightier than your words. Normally it is pen is mightier than sword. No contractor or department will go after the contractor with a sword in hand, that you do the work, else I will kill you. Then lastly, it is the right of termination of contract. For the contractor, I've explained one other instance. It is the second part becomes the employer's right. If the material is available, the site is available, the contractor does not do, what will the employer do? They will terminate it. Now, this termination is also challenged before the arbitrator. One has to be very specific with the reasons. If you have the reasons, you are freely employing, which becomes part of. You are not audible. You were speaking something.
No, sir. No, nothing.
Then approval and acceptance is to be seen. Approval and acceptance. If no approval and acceptance, nobody in the world will be able to help you out. And for liquidated damages in such construction contract, one has to be very vigilant and has to follow the law laid down by Kailash Nath Associates versus DDA judgment. Because it says clearly, demonstrate the actual loss. Be specific and clear on your liquidated amount. No talking in the air. Evidence, authentic evidence, rightful evidence, and to the point evidence. You get everything. Court will award likely amount. The court will not go by your hypothetical amount. By claiming a hypothetical amount before the arbitrator, you are not enriching anyone. You are enriching only arbitrator. Because more the claim, more the fees of arbitrator. Arbitrators are happy. They will instigate you. You please examine your claim. It can be more than that. And in certain fixed value contracts, and if everything is going right, no liquidated damages. Or certain circumstances are also given and justify that this contract can actually be completed in a period of 2 months or so, but actually the period is fixed as 4 months. Then they say in the contract itself, keeping into all factors in mind, the time is fixed as 4 months or 3 months or 5 months. This is, I think, the limited this session required. Otherwise, it is a big subject which can be only understood by facing the music. Once you get into this, you will read this, you will get to know. It's a very healthy subject. Any questions from anybody?
Yes, sir. I have a question.
Ritik?
Yes, sir. Sir, first of all, thank you so much. It was really good insights which you provided on arbitration, sir. Sir, yes, sir. So, sir, my question was like you used the words to be vigilant several times. Yes, sir. So, the word vigilant raises a question in my mind that what kind of clauses we should look for in a contract uh, which can be problematic for us in future in any commercial contract or construction contract, any kind of contract which can give problems to us in future. So
Just listen to me.
yes, sir. Yes,
You drive a car?
yes, sir. I do.
Have you ever seen speed breaker?
Yes, sir.
Have you ever seen a big moon-like crater on road?
Yes, sir. Most of the times. Yes,
And
sir.
after visiting first time, on the second ride to that road, were you vigilant?
Yes, sir. Yes. Right, sir. Right.
So the answer you have already got, I believe. You have to just examine the construction level contracts. Google and other judgments on the subject give you clear insight.
Yes, sir. That's right, sir. But sir, yeah, the question was like if there any clause which we should add in our contracts in future if I'm like drafting a contract, is there any clause which can be really helpful for us?
See, it depends on the requirement of your clients.
Very well.
Okay. So there are no shortcuts, I guess.
There can't be any specific clauses. You
Uh,
have to intelligently examine them. Many
Right.
times on these lawyers group, I feel strange. People are putting message, please give us the draft of section 11, 12.6. Please give us the draft of execution petition. Please give draft of this and that. Unless you work on that, why do you want to make your life very simple?
Very well.
Right, sir. Right, sir. Thank you, sir. Thank you
One
so much.
question from my side, sir.
Shyam, how are you?
Fine, sir.
God bless you.
Just I want to one clarification from your side because it's related to my ex organization.
Yes,
That
please go
is
ahead.
DMRC versus Reliance.
Okay.
Regarding high-speed metro, airport metro.
Okay. In which Reliance
What was the?
DMRC lost?
No, we got benefited because first of all, the Supreme Court, I think the
Chalo, leave it. Come to the query.
Yes, sir.
award was
Part of time.
in favor of Reliance. And what was the main reason why it was turned in favor of DMRC? That's only question.
You tell me the reason. What is your view on that?
I got in detail, and as per the terms of the contracts, the DMRC has acted vigilantly regarding the apprehensions of the Reliance, and despite that, they have terminated the contract without any reason, and that is
So
the main
the
reason
magical
because
word
of
you
which,
used was apprehension.
yeah, yeah,
Magical word you yourself used is apprehension, expectation.
yeah.
So that changes the game, no?
Yeah.
So
I
you
read the
yourself know the
complete judgment.
answer. You yourself know the answer you're asking from me.
So I was trying to that everybody should know and in clear terms from your side. That's why I
Shyam,
was
it is a long topic and it's a Gita of judgments. We'll speak individually on this.
Right.
thanks, sir.
Sir, I have one question, if you will allow me.
Yes, Naveen sir, please tell.
Sir, I have one question. I just want to take, like, is it there any suggestions from your side by the way we can introduce in such a way that the contractor should be promoted towards the arbitration?
See, contractors are very miser in paying.
Yes, that was the main issue. Like the payments are very less, like 2 lakh, 3 lakh, 5 lakh, 20 lakhs, 40 lakhs. There are lots of contractors whose payment are very less. They will not go to
So
the court.
what you can do is, if you are really keen, ask them. I will make you win the case. In my initial fees will be so less. If you win, give me percentage. It all boils down to money.
Yeah, that's the main thing. Actually, I have done BTech
And
in civil
secondly, they do
engineering.
not want to fight with the department because
Yes.
if they get penalty or punishment in one contract, they are already doing 10 of them. And normally they get contract by things which cannot be spoken on screen.
Sure.
Amit ji has right one question, sir. Amit ji, are you there?
Yes, I am here. My question is,
Yeah, please
uh,
ask.
if the employer doesn't make the payments, which are scheduled payments, and can the contractor stop his work in between, or if the work is over, can he refuse the warranty benefits?
Understand that the contractor has to take steps for recovery of money. The warranty benefits cannot be denied. If he wishes to stop the work, keep in mind that 3 months successively or 4 months successively, he has to keep writing letters to them. Or if it is required, that go for an arbitration and obtain an interim award.
Thanks a lot. Thank you.
That is the reason
Really
interim
helpful.
award and final award. For interim relief, Section 9 and Section 17 of Arbitration Act. For interim award, go to arbitrator and obtain an interim award. Don't take any steps which will lead you to blacklisting.
True. I understood. Correct. Thank you.
Okay.
Anybody else? So there is no question, sir. It is very, very insightful, sir. Very useful to all young lawyers, and everybody will definitely appreciate it.
See, the moment you told me, no, most of these will be young lawyers, I did not get into complexities.
Yes.
I made it very simple.
Very simple, sir. Very simple.
So that everybody is clear about the basics.
Right.
What money can do, one should know what money can do.
Right.
What is the abuse of power? One should first know abuse of power.
Very well, sir.
What power can do? One should know the negatives and positives of the power, how to use it. So
Perfect.
knowledge is like blessing of Mata Saraswati, Goddess Saraswati. During these auspicious days, I believe I was able to give backdrop and background of my experience, which can be used by them.
Absolutely, sir.
And
Absolutely.
again, I will lastly say, pen is mightier than words. Pen is mightier than sword. Every contractor and every employer or lawyer should know that written communications with acknowledgement or postal receipts or email receipts are more important for any subject or any problem of the world.
Perfect, sir.
No written communication, no claim justification. You sit on the shore of the sea, you will only hear to all kind of shore.
Perfect.
There you cannot write anything and send it to. Go sit on the table, use your pen, use your computer, write it.
Right.
Now, simple question Alok asked, what should we do? It is a common sense. If the employer is not paying, go for an arbitrator, get it appointed. A claim, single one claim would be that please release my this amount. I'm still to do different parts of the job. If my money is not released, closed.
Right.
At least once an arbitration starts, the money is secured.
Right.
You sit silently. I must tell all the young colleagues, these all government departments, DD, MCD, and other similar Delhi government or Union of India, they do not pay the fee of lawyers timely.
Right.
If the lawyers can work for 6 to 8 months without money, and at the end of the day, the fees is also 3,000, 4,000 rupees.
Right.
Don't at least let the contractor suffer. Do their cases, earn money from those sources.
Right. Very well advised, sir. Very good advice, sir.
Thank you.
Anybody else chatting? If I'm able to get any question from anybody, thanks for such a valuable presentation, making concept of arbitration in a simple and comprehensive manner. These kind of
The
comments
list
are
of
there.
judgments which are really important. 1964 was Fateh Chand on the aspect of compensation and damages. Then there are in the middle there are different judgments, and then there are judgments of this Kailash, and these are followed and all. Or I will since these are festive days, we also get occupied with
Yes,
it is
yes.
tough for us.
Right.
So I will, you can get in connect with me. I
Right,
will
sir.
see the list of judgments. You can share those judgments with them.
Right, sir. Thank
And
you.
then you can have a meeting on these judgments, asking, I will ask them questions that what did you read and interpret on this judgment?
Very well, sir. Very well.
Everybody is ready for that?
Yes.
No,
Yes, sir. Ready.
we are truly Indians. If somebody says clap, nobody will clap.
No, mic was not open. We are ready.
Yes,
Hey,
sir.
sir,
Why
mic
did
was
you
not
keep
open.
mic
That
off?
was the reason. It is really a big round of applause to sir. That's really
Thank you, sir. Thank you.
Very well.
Thank you.
Right, sir. Thank you.
God
very
bless
much.
you.
Right, sir. It's our honor, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you.
Thank you, sir. Thank you.
Thank you very much, sir.